All right, we're recording now. I'll go ahead and read the intro. We'll get started. Hi, I'm Sarah, coach with Alt Legal, and I'm here today with John Miranda, a former examining attorney with the USPTO, who is now a trademark and copyright associate at Abelman, Frayne & Schwab, a boutique IP firm in New York. John has joined us today to talk about surname refusals. So let's get started with some questions. John, thanks so much for joining us today. My first question involves several parts. Oh, wait, you know what, John? I'm so sorry. I'm going to redo that because I realized I was recording on the wrong slide. I want to record it on this one. I'm so sorry. Let me restart that. Sorry. All right. Hi, I'm Sarah, coach with Alt Legal, and I'm here today with John Miranda, a former examining attorney with the USPTO, who is now a trademark and copyright associate at Abelman, Frayne & Schwab, a boutique IP firm in New York. John has joined us today to talk about surname refusals. So let's get started with some questions. John, thanks so much for joining us today. My first question involves several parts. The first question, can you give us an introduction to surname refusals? What is the policy behind surname refusals, and why are surname refusals on the rise?
Thank you. So trademark surname refusals actually have their roots in common law. Traditionally under common law, if a trademark consisted of a common surname, then the trademark rights would not attach. The reasoning being that if it's a common surname, that means it's shared among many individuals, the surname's shared among many families, and people tend to do business under their surnames. So the policy rationale was that in order to keep people free to conduct business under their surnames, we can't encumber common surnames with exclusive trademark rights unless, for example, the owner of the trademark established acquired distinctiveness, so they could show that the meaning of the trademark had changed in the minds of consumers over time to not be perceived as a common surname, but rather to be perceived as the trademark owner's brand identifier. So that's where it comes from in common law. Now in the US, trademark law is pretty much all federal. It's all governed by the Lanham Act of 1946, which is the primary statute which governs US trademark practice. And the surname refusals were codified in the Lanham Act under Section 2E4. So now the way that trademark surname refusals in the US generally come up is somebody applies for a trademark with the US Patent and Trademark Office, and they get an office action, and they get a Section 2E4 refusal in which their trademark is rejected as merely a surname. And apparently surname refusals are expected to be on the rise over the next few years. The reason being that as some law professors and academics have pointed out, we're kind of running out of distinctive words in the dictionary that can function as trademarks. Basically, we're running out of trademarks. We're running out of room on the register for new distinctive trademarks. So some expect that to result in people and companies just kind of resorting to the traditional practice of conducting business under their last name. So in that case, we're going to see a rise of Section 2E4 refusals from the USPTO over the coming years.
Absolutely. All right, so the next question, how do trademark examiners determine if a surname is registerable or not, and what factors are considered?
So when a USPTO trademark examining attorney is considering doing a Section 2E4 surname refusal, maybe they get a trademark application and they think it looks like a surname or it consists of a term that may be a surname, so they decide to do some research into whether it is a common surname. The first thing they usually do is they conduct a LexisNexis public record search. And I mean, at least that's the software that they were using when I was there. It could have changed by now, but I'm assuming the general practice is still the same, which is they review a public records database that consists of phone and address records. And that basically retrieves information about people from all over the country and tells them how many people in the United States have this surname. So generally, at least when I was there, and this isn't anything from the TMEP or any type of regulation, it was just kind of the general internal practice when I was there. The magic number that we were told to look for was about 150. If 150 people have the surname, then the presumption is kind of that you're going to lean toward doing the surname refusal, especially if it gets closer to 500 to 1,000. Then the presumptions generally they're going to do the surname refusal, depending on other factors, of course. So that brings us to the next factor, which is the surname, is it the surname of anybody who's connected with the trademark applicant? And for the most part, the issue that comes up here is that the trademark is the surname of the person who founded the company that's trying to register the trademark. In this case, a lot of times the examiners will go to the applicant's website. There's like a bio or about or company history section, and they'll use this as evidence to substantiate factor number 2. And I guess, so as we're going to kind of discuss, all the factors are related. There's some interplay between them. So even if a surname is rare, sometimes you can still get a surname refusal if it's clear from the applicant's website that this is the surname of the person who founded the company, or it's anyone connected to the company. The third factor is also very important, and that's whether the trademark has any recognized meaning other than a surname. So we'll have to get into this one in more detail later. But again, so even if a surname is very common, like Smith, for example, probably one of the most common surnames in the country, that's actually not treated primarily as a surname because the wording Smith has other meaning besides being a surname that's recognized. So third factor is very important. Fourth and fifth factor, fourth factor is probably the least important, and that is whether the trademark has the look and feel of a surname. So this is, it basically means, does the word that they're trying to trademark have the structure and pronunciation of a surname? So this is kind of a tiebreaker sometimes. It's you do the analysis with all the factors together, but look and feel is kind of considered in connection with, even if it's a rare surname, and if it's like the name of the company's founder, then maybe they look to the look and feel factor to see whether they think that consumers are likely to perceive this mark as a surname. And then the fifth and final factor, it's is the surname combined with any additional distinctive elements? So generally, if a surname's combined with a distinctive design or other distinctive wording, that's something that could result in the examiner deciding not to do the surname refusal.
Got it. Thank you. So the next question, how can we distinguish between marks that are primarily merely a surname and marks that contain surnames but also hold other significant meaning?
So the name of the refusal is primarily merely a surname. Keyword is primarily. Lots of common surnames. King, for example, is a very common surname. It's not primarily merely a surname. It has a very well-known meaning, just King. So the trademark King, despite being a common surname, would not be refused as primarily merely a surname. So generally, there's certain evidence. Let's just like put ourselves in the shoes of somebody who receives an office action from the USPTO, gets a Section 2E4 refusal because their applied for trademark is primarily merely a surname. Think about how they might be able to respond to that, what type of evidence they could present to the examiner to overcome this refusal. So just based on the King example, some of the most persuasive evidence to overcome a surname refusal would be dictionary evidence, showing that this mark, which the examiner is claiming as a surname, actually has other recognized meaning. Wikipedia is actually a good resource for this. Sometimes the examiners use Wikipedia as evidence. Like they'll just search the surname in Wikipedia, and if the search results show that, like if you search Jones, for example, and the Wikipedia search results show that a search for Jones comes up with a list of 1 million people with the last name Jones, that's kind of evidence that this wording is mostly a surname. That's how people are going to perceive it. But sometimes you can respond by searching for Wikipedia and finding what else, what other significance this wording has. So generally, so there's some evidence that the examiners find more persuasive, some that's less persuasive. Geographic like if a surname has mostly geographic meaning outside of being a surname, that could actually be less persuasive because they know that towns and cities are usually named after somebody's surname. Some of the more persuasive evidence, though, is if a surname is also a common first name, that actually is something they consider persuasive, and that's actually a common way in which a surname refusal can be overcome. For example, my last name, Miranda, is actually a pretty common surname. I think that it's definitely not rare. It's definitely a very common surname, but it's also a very common first name. So Miranda would never be refused as primarily merely a surname, or if it was, it could easily be overcome just because it has that other significance.
Right, got it. Makes sense. So is it possible to overcome a Section 2E4 refusal by combining the surname with other elements?
So it depends on what type of elements the surname is combined with. So if a surname is combined with some like wording that's descriptive or geographically descriptive or generic or informational, that's considered non-distinctive wording by the USPTO. So combining a surname with wording such as that, it's still going to result in the applicant receiving a Section 2E4 surname rejection. For example, if you tried to trademark Jones Plumbing for plumbing services, plumbing is generic. So that's going to result in a Section 2E4 refusal. If you combine a surname with distinctive wording, however, that's sufficient so that a surname refusal should not issue. And designs are a little bit more complicated. So if you combine a surname with a distinctive design and a logo, then a surname refusal should not issue. The reason being that the addition of the distinctive design means that the commercial impression of the mark is not primarily merely that of a surname. It also has the impression of the distinctive design. However, if you combine a surname with a design which consists merely of basic geometric background shapes, sometimes you'll still get the surname refusal. The reason being that the examiner decides that these basic geometric shapes are just mere background carriers and that they're not distinctive enough to overcome the primary surname significance of the trademark.
Yeah, got it. Thank you. So what more can be done to register a mark that has received a Section 2E4 refusal? And can you register on the Supplemental Register or try to prove acquired distinctiveness under Section 2F?
So Supplemental Register and acquired distinctiveness are generally both options if you get a surname refusal. Assuming that the mark is otherwise eligible for the Supplemental Register, meaning that it's being used in commerce or it's based on a foreign registration, intent to use trademarks aren't eligible for supplemental registration, and Section 66A Madrid trademarks are not eligible for supplemental registration. But assuming it's otherwise eligible, surnames or marks which are found to be primarily merely surnames are generally allowed to register on the Supplemental Register. It's usually a pretty easy process. The examiner is never going to reject a surname on the Supplemental Register. Before an applicant decides to proceed on the Supplemental Register, though, they need to be aware of the benefits and drawbacks because there are some pretty significant drawbacks. So I guess first, the benefits of the Supplemental Register as opposed to the principal are you still get the trademark registration. You're allowed to use the trademark symbol like the R and the circle on it because you basically get to give notice to the world that you do have a trademark registration for this mark, even though it's on the Supplemental Register. You're still allowed to file a lawsuit in federal court for trademark infringement with the Supplemental registration. And you're still allowed to use a supplemental registration to apply for a trademark in a foreign country based on your US registration. So there are some benefits. Supplement marks that are registered on the Supplemental Register are considered very weak by the USPTO and just by judges and courts and trademark lawyers at large. So generally, if you have a supplemental registration, the USPTO is not going to give it a ton of protection from similar marks registering alongside it. So usually, like if you have a trademark registered in the Supplemental Register, the USPTO will prevent an identical mark for very closely related goods and services from registering alongside your mark, but it's not the same level of protection you get on the principal register. Additionally, if you have a supplemental registration, you're not going to be eligible to claim incontestability after 5 years. And it's also very hard to enforce your trademark rights with the supplemental registration. The reason being that in federal court, it does not give you a presumption of ownership or even a presumption of exclusive rights. So supplemental register definitely has its drawbacks, which is why it's always better if you get a refusal for your trademark being primarily merely a surname. It's pretty much always better to try to prove acquired distinctiveness and register the mark on the principal register based on Section 2F. So generally, if you've been using your trademark in U.S. commerce for 5 years or more, you're going to be eligible to register on the principal register based on acquired distinctiveness, Section 2F. It's pretty straightforward. If you haven't been using it for 5 years in U.S. commerce, though, it's a lot more difficult to establish acquired distinctiveness. If you haven't been using it for 5 years in U.S. commerce, you're going to need to submit extrinsic evidence to the USPTO showing that your mark is it's acquired distinctiveness basically based on unsolicited media coverage, based on consumer surveys showing that consumers recognize your brand, and just based on sales and marketing figures. Basically, you have to show that you're doing pretty well, like you're successful. Like, I hate to say the word famous because that has other meaning in trademark law, but you basically have to show your brand is kind of famous. So it can be quite difficult, but if you have been using your trademark for 5 years or more in U.S. commerce, it's pretty straightforward. So that's generally the ideal situation because you want to be on the principal register. You don't want to be on the supplemental register.
For sure. Well, thank you so much for joining us today, John. Those are all the questions I have. We really appreciate all of this helpful information and for you walking us through surname refusals.
Okay, thank you for having me.
All right, great. Well, that was easy. You did awesome.
Oh, thank you. I think that was the longest I've ever talked like straight through without taking a breath in a while.
No, you did great. I definitely didn't. It seems painless. So you did really, really good.
The last one I was kind of running out of breath, but
that's okay.
I didn't want to be like short or anything. So
no, it was a lot to talk about. You covered it and it was succinct and easy to understand. So that's exactly what we're looking for.
All right. Well,
awesome. So yeah, let me tell you next steps. So I'm going to take this back to the team and they're just going to do a little bit of video editing and make sure everything looks good. And once I hear back from them, I can get back to you in terms of when I'm ready to publish, and then you can start sharing it with your friends and colleagues.
Okay, sounds good. Just keep me posted. Let me know if you need anything else from me.
Okay, perfect. Well, thank you so much. We really appreciate it.
All right. Thank you very much.
All right. Take care.
All right,
bye.
Bye.